SJC-13858, Commonwealth versus Wayne LeBlanc.
Okay, Ms. Spade.
Good morning. May it please the court. Hallie White Spade, Assistant District Attorney for Middlesex on behalf of the Commonwealth. With me at council table is ADA Madison Bush, who is the trial prosecutor in this case. We are here because the single justice abused his discretion in ruling that this was not an extraordinary situation warranting this court's intervention. This is a victim crime, a crime involving domestic violence. It involves firearms. It involves the firing of a firearm in a residential neighborhood, endangering not only the victim, but the public. It is a clearly erroneous ruling that violates clearly settled law and could have been easily corrected. Not only is it erroneous, it puts the Commonwealth entirely out of court. And that puts us already a step beyond the situation described in Commonwealth v. Fontanes, where there's a good deal of discussion about how maybe the Commonwealth could have proceeded without this evidence. This case is over without the victim.
What was the evidence before the single justice on the argument that you just said that this put the Commonwealth out of court and so forth?
It's the victim's statements, the victim's testimony. Without the victim's testimony, we have, it is entirely that the defendant, we have a smashed side mirror and a bullet hole in a stop sign. And that is our evidence without the victim's testimony.
So do we know this is not a case, as sometimes occurs, where there were statements to police officers who could testify?
I don't know how they, well, I don't know how they could come in without the victim.
Or observations?
They observed she was upset. They saw the bullet hole in the sign.
Was there excited utterance issue?
That's not been litigated. I mean, that would go to the reliability of the statements to police.
Well, Attorney Spade, if we're going to go back a couple dominoes, and I understand and I agree with you that this is a serious case, what I struggle with is this is one of the rare cases where the trial judge really went through a hearing with the complainant here and made some findings about how this particular, not uncommon in domestic situations, was not cooperative from the beginning, but invoked the marital privilege.
Okay, there has been no hearing involving testimony from the complainant. Mm-hmm. My understanding is that on October, was it 27th, the complainant victim came in, asserted her privilege. There was a brief colloquy, but there has been no testimony in court from the victim.
Agreed. So, I was speaking specifically about the colloquy to find that the marital privilege was properly invoked.
But the privilege was not invoked until that hearing on October 22nd. And we have, from June 2nd to October 27th, we have hundreds of calls in violation of a court order discussing, yes, it's not in every single one of these, somewhere around 800 calls, but several of these calls involve extensive discussion from the defendant of her, quote, options. Mm-hmm. And he tells her, this is on June 26th, okay, so like I said, the options are you can go on the stand, testify, and then they have me. That's enough to convict me. You could also invoke your spousal rights. Okay. And she says, yes, that's what I want to do. I talked to your lawyer about that, which I will stay in here for the 120 days. And if that's the plan, then my lawyer has to get on the ball and she has to tell the court, tell a prosecutor, which I thought she was going to do that today. Then she needed to know that you were going to fucking invoke your spousal rights. Then he tells her she will not be testifying at the trial. So they can summons you to court, but that'd be stupid because you're going to plead the fifth. He doesn't mean that. He means invoke privilege because you're going to take your fucking spousal rights and not say a damn thing. All you had to do in the beginning was recant to her private investigator, and it goes on from there.
But if even with that wind up, didn't, for purposes of the forfeiture by wrongdoing exception, didn't the trial judge make a specific finding that the defendant did not cause the unavailability of the complainant?
She made that finding, and in making that finding, she applied the wrong legal standard. Because this court said in Edwards, first, this court said quite appropriately, what may appear as an agreement by a witness not to testify or a witness's independent decision to avoid testifying, in fact, may be a product of coercion, pressure, and threats. And this court doesn't need a lecture from me about how domestic violence victims will try to placate their abusers. This court went on to say in Edwards, a finding that a defendant somehow influenced a witness's decision not to testify is not required to trigger the application of the forfeiture by wrongdoing doctrine where there is evidence of collusion. This court said collusion, common activity to make that happen. And so
I guess what you're saying, I misunderstood your argument in your brief then, because I actually thought that what you were doing was attacking the findings that the judge made. And I take it now, and I think that's a very hard row for you to hoe, or whatever the expression is, right?
That's a much
So I hear you now perhaps arguing that accepting the findings of the trial court judge, there was legal error because she set the bar too high for the forfeiture by wrongdoing doctrine.
I think that's a much better formulation of the Commonwealth's position than probably actually appears in the Commonwealth's brief. And if I framed that inartfully, I do disagree with those findings. That's neither here nor there, obviously.
What would be our standard of review for the findings? I mean, that's what or let alone.
I think the findings are what they are.
Not even our standard of review of the single justice's review of the judge's findings. It feels to me you've got two levels of abusive discretion to get over. That's tough.
There is the finding that this was not an extraordinary situation warranting intervention.
Right, and then
but the single justice did not reach the merits. The single justice did not touch the merits.
Which is all the reason why Justice Stewart's question at the beginning of oral argument is so important. Not that all of Justice Stewart's questions are not important, but where did the Commonwealth argue that its case was over?
It's
but
certainly in our
for the single justice reaching the merits.
I think that is in our petition.
I'm sorry?
I think that is in our petition.
Can you show me where?
There were so many pages of cumulative record. I think it's part of the argument that we have no other avenue of redress because we can't appeal from an acquittal.
I'm sorry, where was that?
But that's on page, of course I've closed it up.
I thought that's why there was such a heavy reliance on Fontenez.
Yeah.
For that proposition.
No, absolutely. For that proposition that, evidence that takes us out of the prosecution.
It's on page 45.
Thank you. Yes, there it is. The Commonwealth is aware of no other statute or rule permitting interlocutory appeal of a judge's denial motion in limine. If the defendant is excluded and the defendant is acquitted, the Commonwealth may not appeal. I mean, does it say we're out of court explicitly? I think that's implicit in the nature of our.
Well, respectfully, I would understand that sentence as implying that even if this decision stands, a trial was going to go forward, which is not always the case, right? When there's a motion, sometimes the guns and the drugs are just gone, and the Commonwealth brings a petition saying we cannot prosecute, and this doesn't say that.
It doesn't say, it does not say it in so many words, I concede that, but I think it's implicit in the nature of our argument and in the nature of the error. Excluding evidence that otherwise would have been admitted pursuant to forfeiture by wrongdoing. But I just do want to emphasize that in requiring the Commonwealth to have shown that the defendant, anything the defendant did was the somehow efficient cause of the decision not to testify, the judge committed a legal error, error of absolutely firmly settled law that's been the law since Edwards, and simply set the bar too high for the Commonwealth. And my time is up, so unless there are further questions, we'll ask the court to reverse the single justice's decision. Thank you.
Thank you. Attorney Rangabiz.
Good morning. May it please the court. David Rangabiz for Wayne LeBlanc. With me at council table is Kayla Wheaton, who represented Mr. LeBlanc in the trial court. The issue presented in this case is whether Justice Kafker abused his discretion when the Commonwealth did not give him the evidence that would have allowed him to exercise that discretion, and, as your honors have noted during the Commonwealth's argument, where the Commonwealth did not argue the thing that they're now arguing is an exceptional circumstance. So the judge below based her ruling, her findings of fact, on those recordings, those jail calls. As she said at the hearing on the Commonwealth's motion to reconsider, she actually listened to them twice. And she listened to those recordings and then used exactly the verbiage of the Edwards-Zerlong case law. The Commonwealth has failed to prove that the defendant was involved in or responsible for procuring the witness's unavailability. That's in the appendix at page 38.
So do you disagree as a legal proposition that that's what the judge has to look at, or is there more kind of holistic view that the trial judge could take?
I think the judge did exactly what the Commonwealth asked her to do. Justice Wolohojian, your question about an error of law, I sort of thought was how the Commonwealth was framing it. And all the judge did here was answer the argument the Commonwealth was making. If I could just walk through the procedural history. So under Edwards, there are three paths to forfeiture by wrongdoing. This is Edwards at 541. There's basically coercion, the coercion theory, physical prevention, or the third thing we're now talking about, collusion. And the Commonwealth's lead argument to Judge Kahlo was squarely in the collusion, or the coercion camp, basically arguing, look at all these statements, everything that was just quoted. This is a coercion case. He caused her decision not to testify. Now, I'm the appellee arguing an insufficient record here, but if you would accept my representations as an officer of the court, there was an hour of arguments during the hearing below, and ADA Bush argued this as a coercion case. She argued he pressured her, he forced her, he was angry and aggressive, her decision-making capacity was stripped from her. That's the argument the Commonwealth made below, and then Judge Kahlo says, I don't agree. I've listened to the recordings, this was a voluntary decision she made, and so she's answering the argument the Commonwealth is making, and then the Commonwealth comes back on a motion to reconsider and makes essentially the argument they're making here, that you don't have to find that he's a causative effect. This is, okay, you disagree with us on coercion, we're now stuck with a bad standard of review, so let's make this a collusion case. And they cite the relevant language of Edwards that they cited just before you, and the judge says, that too? No. She listened to 15 minutes of argument in the motion to reconsider hearing from ADA Bush, who laid out their whole shift from a coercion theory to a collusion theory. And she said, I'm going to reject that as well. She listened to all the calls. She rejected the coercion argument on the facts in the calls. Then she rejected the collusion argument on reconsideration. So, what they're trying to do is sort of turn the factual loss on coercion into legal error on collusion, right? So I agree with the way the Commonwealth is talking about what the requirements of collusion are, but they argued this as a coercion case. The judge found against them. Then they came back on reconsideration, argued it as a collusion case, and the judge found against them again, using exactly the verbiage of Edwards and Zerlong, right? The Commonwealth did not prove the defendant was involved in or responsible for procuring the witness's unavailability. That's not boilerplate. That's taken straight from Edwards when it talks about what is the showing that the Commonwealth has to make. Now, Zerlong describes all these things as factual findings, right? So these are all factual findings being made, and I can't explain the importance of these calls any better than this court did in Edwards when the situation was flipped and the court had the calls and the trial court below hadn't listened to them.
This has to do with the legal error. What's the What remains of the Commonwealth's case?
I think the Commonwealth just laid it out. I think there's potentially her demeanor. Maybe there was something in the sign that he was alleged to have shot at. I mean, far be it from me to say the Commonwealth has a strong case regardless of this, but I think their case would be weak, which, if not non-existent, which I think goes to the error they made by not arguing this in front of Justice Kafker. And I very much disagree that it's implied by the argument that they were making. And we sort of know that for sure because of the notice you all enter on all of these cases. When you get over that 221 threshold, you always say, just because we found that you have no alternative remedy does not mean this is an exceptional circumstance. So make sure you argue exceptional circumstances. So the sort of docket entry that enters and opens all these cases sort of is diametrically different in opposition to what the Commonwealth is arguing here. But just to go back to sort of the importance of having the calls, I just think it's bizarre that they're not here. And this court explained in Edwards, when you all listened to those calls and the trial judge hadn't, said, having listened to the recordings in full, we're of the opinion that they provide significant additional insight and evidence relevant to the application of the forfeiture by wrongdoing doctrine to these cases, and that their full import cannot be gleaned from the Commonwealth's summary of those calls, right? That's equally true here. It's really important to have these calls. You know, again, I've listened to them. These are 2 hours worth of calls. The Commonwealth is plucking out a handful of sentences and then using them to portray this as a deeply coercive effect. Judge Kahlo listened to those calls. She listened to them twice, she said, and there's just nothing there that satisfies the requirements of the forfeiture by wrongdoing doctrine. She's so found. And then when they shifted to this collusion theory to sort of be the primary thrust of their argument, she's so found again under the appropriate standard. So there's no error of law in answering the primary argument made to you. There's no coercive effect here. And then answering this sort of seriatim argument, okay, I don't find collusion here either. She addressed both under the appropriate standard. The motion to reconsider, I don't want to say it's verbatim, but it's a lot the same as the brief to your honors in terms of its merits portion. Just saying, you know, finding a cause, the responsibility for the decision is not required under collusion. She considered it. She heard 15 minutes of argument. And so, you know, things happen fast in the district court. Judge Kahlo really slowed this down. She listened to the calls. She heard the Commonwealth's argument for the better part of an hour, and then 15 minutes more on reconsideration. And she really gave this, you know, a really full hearing. That's why, you know, like the tone of the appellate papers toward Judge Kahlo, like in footnote 3, was a little bit dissonant because it was just, it's so clear that she gave this really careful attention, applied the appropriate standard again when the argument shifted. And now we're here, and you all don't even have the evidence that she relied upon. So it's not, you know, far be it for me if sort of we pin the merits and go back to exceptional circumstance. Far be it for me to psychoanalyze Justice Kafker because I'm not nearly as intelligent as he is. But I think the court's cases under Fontana say you can do a sort of cursory peek at the merits, but when you're doing this sort of threshold determination, and I think it's maybe fair to think he took a cursory peek at the merits and saw this as a case-specific evidentiary ruling where I don't even have a record to make an assessment of the sort of the person who is actually exercising their discretion, and this is up on me in an abuse of discretion review, and the Commonwealth hasn't made the argument that their case is dead. That's not an exceptional circumstance. So that's what he was confronting, and that's what this case is. So I would urge the court to affirm with no abuse of discretion by Justice Kafker. And if there are no further questions, I'll rest on my brief.